All right, well, I'll get right into it. Just one moment here, I'm going to share my screen. All right. Well, hello, everyone. Thank you for joining us this morning. My name is Thomas, and I'm a social equity representative with the Marijuana Regulatory Agency. And today joining me is Courtney, who is also a social equity representative with the Social Equity Program. And today we will be covering some great information regarding our program and the resources that we provide. If you have questions, please feel free to email us at mra-socialequity@michigan.gov. That email address again is mra-socialequity@michigan.gov. The agenda for our presentation is as follows. We'll be covering state law or legislative mandates, giving a program overview, an application overview, going over our program resources, and even providing with our contact information. In 2018, the voters in Michigan passed the Michigan Regulation and Taxation of Marijuana Act, or what we refer to as MRMA. And this act includes many things: decriminalization of marijuana possession, home cultivation of marijuana plants, but it also includes our social equity program. So under Section 8 of MRMA, our agency is called to promulgate rules, including a plan to promote and encourage participation in the marijuana industry by people from communities that have been disproportionately impacted by marijuana prohibition and enforcement, and to positively impact those communities. This is what enabled us to create the social equity program. But in order for us to decide how best to implement it, we hosted work groups and conducted surveys to find out what is important to Michigan residents. In the spring of 2019, we hosted 4 work groups in Lansing, 2 in Detroit, and 1 in Marquette. With the 4 work groups that were hosted in Lansing, each day we invited people from different parts of the industry, and we invited those who were licensed under the Medical Marijuana Facility Licensing Act, or MMFLA, municipalities, attorneys, and individuals or businesses interested in participating in the adult use market. After these work groups, we also had a survey available where we had 688 responses. With the feedback, we were able to start developing our program. Our program strives to go just beyond encouragement, though. We also strive to help build any skills or training needed to create a sustainable business within a growing market. We want to put those harmed by marijuana prohibition in a better position to participate in this industry successfully. Our goal is to continue to evolve the program based on input from the work groups to reflect the inclusive nature of the social equity program and to put those impacted in a better economic position, such as owning your own business, employment for those whose criminal convictions have made finding a job difficult, and getting people started with not just a job, but a career in the marijuana industry. We are constantly evaluating the success of the program, and through continued feedback from the public, we've both refined and expanded our services offered to those who have been disproportionately impacted. This leads us into our next slide, which is a map that includes a view of the disproportionately impacted communities. Through public input, we were given criteria to identify communities. The criteria used are marijuana-related convictions and poverty. First, we narrowed down the counties that exceeded the state's average of marijuana-related convictions that is kept at the county level, because not every municipality has a courthouse where convictions may occur. This includes any county that exceeded the median average of marijuana-related convictions between 2008 and 2018. Once we identified these counties, we narrowed it down further to communities where 20% or more of the population live below the federal poverty level. Using the census data, we identified 184 communities that met these criteria. And we expanded our services and offered to those that have been disproportionately impacted. Okay. All right. Notably, we lowered the threshold of poverty from 30% to 20% to include more communities. All right. Another big part of our program is our fee reductions and how they are applied. You may remember that our program requirement was that you live in a disproportionately impacted community, but now that has changed. By meeting any of the program's criteria, you may now be eligible for a fee reduction. When it comes to the residency fee reduction, you must have been a resident in a disproportionately impacted community for at least 5 cumulative years out of the past 10 years. The 5 years no longer need to be consecutive, and you are no longer required to currently live in a disproportionately impacted community. The next fee reduction is the marijuana-related convictions. These criteria used to be for a flat 25% fee reduction. Now, if you have a marijuana-related misdemeanor conviction, you are still eligible for that 25% fee reduction. However, if you have a marijuana-related felony conviction, you're eligible for a 40% fee reduction. The only conviction that we deem as ineligible for a fee reduction are those that have been convicted of a distribution of a controlled substance to a minor. Again, you do not need to be a resident of a disproportionately impacted community to receive this fee reduction. You'll only be required to submit your conviction documents along with your social equity application. Finally, the fee reduction for caregivers is unchanged. It's still a 10% fee reduction. And you can qualify individually under any of the above listed criteria or all 3 of them, as long as you can provide proof of eligibility. Next, we'll provide an application overview. So if you want to apply for the fee reductions that I just mentioned, you'll want to apply for the social equity program first. And the reason being that those fee reductions will be applied to your adult use licensing fees. The first fee being the non-refundable application fee that is submitted to begin the review of your Step 1 application. The next fee will be the initial licensure fee after the approval of your Step 2 application and inspection. Lastly, any subsequent renewal fees going forward as long as you remain eligible for the social equity program. Now I'll allow Courtney to take it from here.
Thank you, Thomas. So it's important for you all to know that the social equity program does a little bit more than just process your social equity application. We also offer a free service to those who are eligible for the social equity program, which is adult use application assistance. And that is exactly what it sounds like. We help eligible social equity participants with questions in regard to the adult use application process, along with helping them gather documents in preparation for their Step 1 application. And most importantly, we assist them with submission of their adult use Step 1 application. So you probably want to know how you can sign up for this free service. Well, first you would need to apply for the social equity program and be deemed eligible. Once you received an eligibility letter from us, then you will be able to sign up for adult use application assistance with one of our social equity representatives. You can sign up by sending us an email requesting an appointment, and then we will work with you to find a date and time that works best for your schedule. Now, before you meet with a social equity representative, we will first need to determine where you are in the process. For example, are you in the information gathering stage? Do you have documents together, but you still have some questions? Or are you at the point where you're ready to submit your adult use Step 1 application? After we figured out which stage you're in, then we will set up a meeting with you, whether it be via phone or through video chat. Again, depending on where you are in the application process, we know that sometimes additional assistance is needed. So we will set up a follow-up session if needed, just so that you can have little to no deficiencies on your application. But if by chance you do submit your application, we will talk to you about your next steps after submission. Now, the social equity program also hosts virtual education and workshop sessions. The first one that I would like to talk to you about is the education outreach session. These sessions are held via Zoom webinar, and most importantly, they are free to the public, and they can be found by signing up for MRA's email updates, following us on Eventbrite, or you can find them on our social media platforms such as Facebook or Instagram. The education and outreach sessions in particular focus on internal state agency resources and internal processes to help identify some of those more common issues that we see as an agency. Now, the reason why we have these education sessions is because we want to be able to provide the public with as much transparency as possible so that you're in a position to make more informed decisions in the licensing process. Now, the second virtual education that we offer is our business workshops. Now, these are also free and hosted by MRA at least once a month via Zoom webinar also. Now, the social equity team does not lead these discussions on the workshop presentations, but this platform is in place for individuals who are interested in the cannabis industry with information provided by cannabis industry professionals. However, since they are using our platform to provide the public with information regarding the industry, we do vet each resource prior to approving their involvement, just to be sure that their goals and information align with both MRA and the social equity program. And our largest goal as the program is to help those that have been disproportionately impacted and to eliminate as many barriers to entry as possible so that they can create a successful and sustainable business model. This is why we have the industry professionals and licensed operators leading the business resource workshops. Now, our viewers are able to take into account during these workshops the experiences that these professionals have had and what they had to do to overcome those barriers that they have faced. Now, another way that we get information out to the public regarding our social equity program is through social media and communications. We handle all of our marketing material, which includes creating infographics, pamphlets, flyers, and any other material regarding our program information and updates. We also compile information from each division and section within the agency and create social media posts to share on our Instagram and Facebook page. That's just so that the public is aware of any changes that might affect their process immediately. Another great place to find information is on our website. We offer public compiled list of resources through what is called our business resource directory. Now, these are vetted businesses who have reached out to MRA and attempt to connect and be a potential resource for applicants and license holders. On our website, you will find more focused information specifically about our program, such as a map of our disproportionately impacted communities, guidance documents on how to properly fill out the social equity application, how to correct a deficiency, and there's so much more on there. We have now come to the end of our presentation, and we just wanted to thank you for your time and for joining us today. If by chance you do have a question for the social equity team regarding our program, you can contact us by phone at 517-284-8599, or you can send us an email at MRA-socialequity@michigan.gov. If you want to learn more about our program and the MRA as a whole, you can head over to our website, michigan.gov/MRA. And to receive additional updates on our current events or tips and tricks on making it through the licensing process, you can feel free to follow us on Facebook and Instagram at Michigan MRA. Thank you again for your time, and I'm going to go ahead and pass it over to Jennifer, who is the State Administrative Manager for the MRA licensing section.
Thank you, Thomas. Thank you, Courtney. Yes, I am Jennifer Piggott. I am the manager of the licensing section. I'm going to try to get my screen shared here. So that should be coming on. So my section oversees the licensing for both medical and adult use. And little history of the regulations that we have to implement. We have the 2008 Michigan Medical Marijuana Act, and this is the Patient Caregiver Registry. Then in 2016, we have the MMFLA, the Medical Marijuana Facilities Licensing Act, as well as the lesser known Marijuana Tracking Act. And these two acts set the commercial licensing process in motion. My data a little bit outdated by about a month or so, but we currently have about 2,000 pre-qualified entities, just under 1,000 licenses ranging from provisioning centers to the labs and transporters, and fees that vary from $7,000 to $21,000. Then in 2018, we had the citizen-initiated Michigan Regulation and Taxation of Marijuana Act. Again, a commercial licensing program that flowed from this act. And we are seeing currently 645 pre-qualified entities, over 600 licenses, and a distinction under the Michigan Regulation and Taxation of Marijuana Act, which I will now start saying MRMA, is that we also have some additional licenses than what we saw under the MMFLA. Addition to the growers and the processors, the retailers, the labs, and the transporters, there's the marijuana event organizers and the micro business. New to this information that I have on the screen is we've also issued a temporary marijuana event, which would be the first one in the state so far. The fees for the different licenses that we have range from $1,000 to $40,000. We also have extra licenses like the excess grow and a designated consumption establishment, in addition to some of the others I just named. So the licensing objectives are to process the applications for the state licenses and conduct the background investigations, and then finally make a licensing determination based on that. The licensing process has to be concluded with a state license issued or a notice of denial issued within 90 days of receiving a complete application. So the licensing process should be completed in 90 days when we're talking about the step 2 process, which is where the marijuana establishment is focused on. The complete application, that's the submission of your step 1 pre-qualification, the step 2 establishment application, coupled with the payment. In addition to licensing components that you'll interact with that are within the licensing division and or section, we also have coordinated efforts that touch on the enforcement division, our field ops team that are in the field to do inspections, the Bureau of Fire Services, Michigan State Police, Treasury, and Raymond. Those will be third-party background investigation components. So when we talk this 2-step process, it's a carryover from how the medical process was created. And the step 1 part of the process is the pre-qualification. This is where we are focused on the individuals that comprise the ownership or management of the entity seeking licensure. So this is where we're focusing on the persons, be it corporations and LLCs or down to the individual human beings. There'll be an entity pre-qualification application. That's the main entity looking to hold the license, looking to seek licensure. You can have supplemental individuals, supplemental entities that are a part of that entity structure. Those would be entities over 10% ownership interest. If you weren't an entity looking to hold the license, you could have been a sole proprietor. So it's you, the human being, seeking an application, and that's individual licensure. So those are the 2 main step 1 types that we would have, is the entity pre-qualification application or a sole proprietor pre-qualification application. You're one or the other, not both. The big thing we see is if you're a sole proprietor, you would be holding licensure in your name unless you obtain a doing business as filing. So if you're operating under a different name than your own, then perhaps you would be seeking an entity pre-qualification application. With each application, there's usually numerous, when it's an entity application, there's numerous individuals that could be involved, or it could just be you and or your spouse. But we typically see supplemental entities, we see the spouses, we see individuals with ownership greater than 10%, and there's also managerial employees. That would comprise the step 1 application. The managerial employee is an area that is sometimes missed within the application where deficiencies could result. And a supplemental application is a requirement of a managerial employee. And that doesn't mean that you have, manager in your name, HR manager or things of that nature. It doesn't by default just make you a managerial employee. When we speak of a managerial employee, we're looking to the employees who have the ability to control and direct the affairs of the marijuana business, or they have the ability to make policy concerning the marijuana business, or both. So we would expect that a managerial employee is somebody that has a heightened role within the company. Those people would be required to submit a supplemental application. Their spouses are not, just the managerial employee. Once we've identified everybody that is comprising the step 1 application, a background investigation would flow from that. That consists of 2 pieces: the MSP, criminal history investigation, and the Raymond financial investigation. Now, that together comprises background review. So you could have your application with a status that you log into the online database and see that your filing says you have a status of background review. With that, you are in this process of either we're relying on MSP or Raymond to conduct their research. So it's out of my staff's hands and into the hands of our third parties that we partner with. The Raymond process can see that process taking about 30 business days to complete, and that is a considerable amount of time. So and I say business days very specifically, and so the background review status that you might see, you could be seeing that for some time. It does not necessarily mean that there's something we're waiting on, or action is necessary on your part, or that staff are not processing something. It's in this period with which we are waiting on those reports to be completed from our third parties. Now, once we receive an application, notice of deficiency, NOD as we would call it, could follow. So once we've commenced application review, and this could be at step 1 or step 2, if there are discrepancies in the information that have been provided, if there are missing pieces of information or supplemental documents, then we would issue a notice of deficiency. And pursuant to the rules, the applicant has 5 days to respond to that NOD in full, or that could lead to grounds for a potential denial. And that's where we encourage, at the time you submit that application, that you have as much of that checklist completed as possible, to avoid this back and forth process of having discrepancies, having missing information that we have to obtain via the notice of deficiency and the communication that we have to do back and forth. Once you've completed background review, there's another chance you could receive a background check notice of deficiency. So once we do receive the completed background review, we could issue a NOD because there's maybe a discrepancy based on something that was disclosed on the application or wasn't disclosed at all, and what the reports showed. That's another time with which you could have communication with the agency to resolve items via the notice of deficiency process. Once you obtain prequalification status, you would be able to proceed with the step 2 process. And the step 2 process now is focused on the actual marijuana establishment and items that are concerning that marijuana establishment. Now that we have identified the people involved, the ownership involved, who should or shouldn't be submitting an application, we're focused on the actual physical marijuana establishment. So again, there's on the screen the different license types that you could be applying for at step 2. And all of these are available on our website and have useful information to access that also contain the checklist with all supporting documents we would expect to see when you submit one of these applications. The step 2 process, it comprises things such as the proof of financial responsibility. This is the insurance requirements. It has the municipality information and general employee information. There's the inspection component at step 2. So the physical marijuana establishment must pass an inspection by both our MRA field ops section and the Bureau of Fire Services within 60 days of submission of that complete application. So if you're in the process of building from the ground up and it's not going to complete within 60 days, we would not encourage you to submit that application until you're going to be at a point in time with which you'd be able to hit that 60-day marker. And this is all tied to the fact that we do have those 90 days with which we need to process that application. So if we have to make a licensing determination statutorily within 90 days, pursuant to the rules, it was established that you have 60 days to get that passing pre-licensure inspection. That still then affords us enough time to complete all the steps that are necessary to get that license approved, invoiced, paid, and issued all within 90 days. If you fail to pass that inspection within 60 days, that could result in a denial of that application. If you've submitted an application and you hit a roadblock in lieu of delaying it and not obtaining that passing inspection within 60 days, you may also withdraw that application. And that does not have an impact on a future application you would submit, whereas that denial could impact future licensing determinations. So if you run into a snag at this point in the process, you could withdraw and resubmit at a point in time with which you're able to comply with the rules and the statute. There's also an added component for the Bureau of Fire Services for plan review, and that's done for the grower, the processor, the designated consumption establishment, and the micro business. They will have to go through a level of plan review with BFS. That's done usually early in the step 2 process, and they handle that directly with the applicant. So we would send you a letter and then you would engage with BFS and their process to complete plan review, in addition to then obtaining your passing pre-licensure inspections by the 60th day. Once you have submitted your application, everything's in good working order, there's no deficiencies, and you've been sent to inspections, and you obtain those passing inspections, that's going to lead us to the point where, assuming everything else is in order, that we can make a licensing determination. When we make that licensing determination, we would invoice you any of the fees you may see on the screen. These range from $1,000 to $40,000. They are established within our rules. So if you want to refer back to what some of the fees that I am showing currently are, you may access them in our rules, which are accessible off our website, michigan.gov/MRA. So some of the common application issues, this is usually how I would conclude any of the presentations I give, is just to kind of talk of some of the common issues that we might see to hopefully get enough of the word out to where we can avoid seeing those issues that delay processing or completion of the licensing determination. So inconsistent organizational documents. That would be items where we see that you have submitted LLC as the company name, but turned in filings for a corporation or for another entity type. So they're inconsistent perhaps with what entity is actually looking to obtain licensure, or the corporations division within LARA has your company on record as a manager managed LLC with a certain name, but you turn in documents where it's member managed of same name. So issues there as to what is truly the management of that company. So those would be areas where I would just definitely encourage that whatever you have filed, the nuts and bolts of what is your company is what you will actually be turning in the application, to avoid any delays with processing as we review those application materials. We also see sometimes lack of complete supplemental applications where perhaps the spouse wasn't turned in. If the person meets the definition of an applicant, their spouse would also be an applicant. And we might see that they fail to include that spouse's supplemental application. That's a notice of deficiency, and that's time that is then spent going back and forth to obtain all the necessary materials to keep that application moving forward. Or we might see missing documentation where things that are on the checklist are entirely not completed and turned in. So the checklist is a great resource, and making sure that you have everything necessary to complete that application. Another area that typically surfaces at the step 2 is concerning the name with which you're filing to do business as. So you could be company X, but you want to have a certain name with which you transact business. Not having that name appropriately documented or on file could be an issue that we would see. So if you were going to be transacting business under a different name, ensuring that you have the doing business as or certificate of assumed names properly filed in the county or state levels and turned in with your application. Additionally, another area of concern is sometimes, as I kind of mentioned earlier in the step 1 process, is the sole proprietor versus entity submission. So it's an either or submission. You're not both an entity and a sole proprietor when you apply to the MRA for a state license. If you are going to operate within your individual name and you're going to be a sole proprietor, you would go that application route. But even you as your individual name, perhaps you created another company, even as a sole member. You don't need to have an elaborate structure. If it's going to be a different name other than your human name, then you would need to be doing an entity submission as opposed to a sole proprietor submission. So that's an area where we see a lot of common issues where we have sole proprietors that are actually meaning to apply as entities. But they do it thinking I'm applying as myself, so that makes me a sole proprietor. But if the business that you're hoping to have licensed is not going to be operating as your name, you need to seek the entity submission. We also see the failure to respond to deficiencies timely. So we have 5 days with which we ask that you respond to your notice of deficiency in full. And this is all to encourage that the application keeps moving forward timely. Additionally, we have 90 days to process that step 2 application. So to make sure that we are able to make that licensing determination in a timely manner. When you receive those NODs, even if you might not have all the items readily available to complete that processing, staying in contact with your analyst that's assigned to process that record is very important to make sure that we know that you're actively diligently working to complete this, or that you ran into a snag and something's caught up in the mail, or whatever the case may be, so that way we know that we may be expecting to receive something is always very helpful. So even if you can't complete in full and you're only completing in part, keeping us updated to that is very important. And then finally, as I said, we have that third-party background review process that can take upwards of 30 business days to complete. And we do see that there are still some instances where due to COVID, there are some court closures and there are some snags of being able to complete the reports in a timely fashion. So just advice to the industry that may be applying that, as quickly as we're trying to operate, and a lot of things have shifted to a remote setting, that there still are some instances where we run into snags, either from the applicant's perspective or our third party perspective, where the COVID-19 pandemic can still cause some delay in completion of our process. But the common issue that most faces the applicants is the delay with which they receive their background review completions, which can take 30 business days, which is roughly, give or take with holidays, 42, 45 days. And then finally, to contact MRA. If you have questions about anything in this presentation, There's the MRA mainline, as well as the general email box to submit your inquiries, MRA-adult-use-marijuana@michigan.gov. And our website is loaded with information that you may view and access to help guide you with some of those questions. And with that, I do appreciate everyone's time today. Thank you.
Thank you, Jennifer. Hi, everyone. My name is Tatiana Grant, and I am the Marketing and Communications Consultant with the Homegrown Detroit program. Thank you again, everyone. I'll be making a couple of announcements. We will be hosting these every Monday at 4 p.m. and you'll be able to watch them here on a live, as well as the replays moving forward. We are going to go to some questions though, and so whoever at the MRA is most appropriate to answer them, please go on ahead and jump in. The first is the application fee for the retailer $6,000 or $25,000? If we can just get clarity on that.
Absolutely. So the initial application has a $6,000 application fee for prequalification. So step one has the $6,000 fee. And then you'll have the licensure fee that is tied to the specific application that you're approved for. So that's where you'll see the $25,000 and the $40,000 or $1,000, depending on the license types you seek.
Got it. Another question is, does the business plan fall under organizational documents?
The organizational documents that I was speaking of are stuff at step one for prequalification. So for how your entity is structured in terms of the main entity, all supplemental entities, and then the governing documents that go along with it, your operating agreements and things of that nature. The business plan is something we would see at step two.
Got it. Why are employees who work for the state not eligible, even though they do not work for any MRA agency?
That is something that is housed within the statute. So I can't speak necessarily to how the rules surrounding statutory requirements for eligibility are imposed and then carried forward necessarily into our rules. But at this point in time, we do have eligibility criteria that anyone meeting the definition of applicant would be required to adhere to. So that would be your spouse, yourself, and not being a government employee is one of those eligibility criteria.
Got it. It appears this is the last question. Is the financial background check reviewed based on your personal 1040, or are they reviewing business credit?
We are looking into individual and business information when we talk about the financial background review. So you're required, one of the supporting documents you turn in is a 1040, W-2s, things of that nature, or explanations as to why they might not be available, or your taxes weren't filed for the current tax year due to different exemptions and the like. But we would be looking into your associations with other businesses and any filings you might have been obligated to pay under that business, as well as individual responsibilities.
Got it. And can you just clarify again, two things? One, the difference between a legacy Detroit applicant, the difference between a social equity applicant, and any clarity you can on the state fees. Because one of the questions we have is, as a legacy Detroiter, are you still responsible for the state fees? So if there's any way to kind of just assist with that part.
So there was a couple things that surfaced in that question. So I can't speak to the Detroit legacy process. That's specific to Detroit. As was indicated on the social equity presentation, there's eligibility for different fee reductions that would carry forward to the state application that you would have when you enter the adult use licensing process. So specifically, those entries into the social equity program guide you into the social or the adult use application process. We can see those fee reductions happen at prequalification, initial licensure, renewal, but I can't speak to what the Detroit process is.
Understandable. Okay, more questions. Is the $25,000 fee paid after the license is approved? And the $6,000 fee was paid and is non-refundable. So I guess just a differentiation.
Yep. So the pre-qualification application fee is a non-refundable $6,000. And the in that case, that $25,000 example would be your retailer initial licensure fee. And that would be invoiced after we have made your licensing approval. So we've made a licensing determination to approve the license. We would invoice you that fee. We would take into account any social equity eligible discounts that could apply to that. And you would be invoiced, you would pay, and the license would issue from there.
Got it. I believe this is the last question. Is the licensing fee just a one-time fee, or does it have to be renewed annually?
Yes, so you pay the initial licensure fee, you obtain your license, and then every year annually, you would renew that license and any other licenses you may have. Your pre-qualification, that $6,000 fee, just for a side note, you pay that one time. And if you seek to take, up a license as a grower and then want to be a retailer, you aren't doing pre-qualification again. That carries forward. So that's a one-time fee. And then every subsequent license you obtain is renewable annually.
Great. So thank you again. As we all know, knowledge is power. So we hope that everyone is able to join us on Mondays at 4 p.m. I'm going to share my screen so you all can see the next one that we have coming up, which is next Monday. And it's on cannabis insurance. And we will be hearing from Amanda Kugler with the Roots Insurance, and she'll be going over the types of insurance you'll need to get for your license, that application that the team spoke about. Beyond licensing, what types of insurance your business will need while operating, and insurance claims in the cannabis industry. I also, again, would like to thank the MICIA for all of their assistance with this program, and the MRA as well. I can actually speak because I have gone through the process and have done it by myself. And that 517 number became very helpful. I did a lot of phone calls on the front end when I just had questions and was even considering making that investment to even apply. And then as I was going through the process, getting the notice of deficiencies and everything, really found the MRA to be quite helpful. They are definitely here to help. Do not be afraid to call and email. I'm sure email may be a little easier. Both have gotten great responses. So highly encourage anyone who's looking to get into the industry, looking to get any sort of level of clarity to respond in those manners. And also come check out our events. Spread the word. These replays will be available on the MICIA website. And that's it. Thank you. I'll hand it back over to Isaiah to close us on out.
Yes, thank you, Tatiana, for that. And you can find these videos on our Facebook page, as of course we go live every Monday at 4, and these will be uploaded to our YouTube pages weekly and also our website, like Tatiana said. And thank you very much. Appreciate your time, Thomas, Courtney, and Jennifer, and hope you guys have a great day.